1 second. That's all it takes. 1 second where someone pulls a trigger and later says, "I had no choice." But in a courtroom, those 4 words don't mean anything by themselves. Let me ask you something straight up. If you had to defend yourself in court tomorrow after a shooting, could you clearly explain why your actions were legally justified, not just emotionally justified? I want you to think about that seriously. Drop your thoughts in the comments, because most people believe they understand self-defense until they see how prosecutors and juries actually analyze it. And what courts look at is very different from what people imagine in their heads. Here's the first thing you need to understand. Self-defense is not about whether you felt scared. It's about whether the law agrees that your fear was reasonable. That word, reasonable, is everything. In court, a self-defense claim usually hinges on 5 core elements. They don't always get presented as a neat checklist to a jury, but legally, they're there. If even one of them collapses, the entire defense can fall apart. The first element is innocence. Were you the initial aggressor? If you started the confrontation, escalated it, or provoked it intentionally, you may lose the right to claim self-defense. Courts look very closely at who initiated the conflict. Did you chase someone? Did you threaten first? Did you pull a weapon early to intimidate? Those details matter. The second element is imminence. The threat must be immediate. Not next week. Not, "He said he'd get me someday." It must be happening right then or about to happen right then. If there was time to cool off, leave, or call for help, prosecutors will argue the threat wasn't imminent. The third element is proportionality. Deadly force can only be used to stop a threat of death or serious bodily harm, not to stop someone from stealing your car stereo, not to win a fistfight. Courts examine whether the level of force matched the level of danger. If someone shoves you and you respond with a gunshot, that imbalance will be front and center in trial. The fourth element is avoidance. In some states, there's a duty to retreat if you can safely do so. In others, stand your ground laws remove that duty if you're somewhere you have a lawful right to be. But even in stand your ground states, juries still consider whether you could have safely avoided the confrontation. Just because the law says you don't have to retreat doesn't mean a jury won't question why you didn't. And the fifth element is reasonableness. This ties everything together. Would a reasonable person in your position have believed deadly force was necessary at that exact moment? Now here's where things get real. Courtrooms don't replay fear the way you experienced it. They replay evidence, slow-motion surveillance footage, forensic timelines, text messages, 911 calls, body camera audio, every word you said before and after the incident. If you shouted, "I'll kill you," 5 minutes earlier, that will be played in court. If you fired after the threat was down, that will be examined frame by frame. If witnesses say the other person was backing away, that becomes critical. And here's something people underestimate. What you do after the shooting matters. Calling 911 immediately, requesting medical aid, remaining at the scene. Those behaviors often support a narrative of defense rather than aggression. Fleeing can severely damage your credibility. Let's talk about how prosecutors approach these cases. They don't ask, "Did the defendant feel scared?" They ask, "What evidence shows deadly force was necessary?" If they believe they can convince 12 jurors that you acted out of anger, ego, revenge, or panic instead of necessity, they will charge the case. They'll look at your prior statements, social media posts, past threats, even training records. If you've publicly said you were waiting for a chance to use your weapon, that becomes a narrative tool against you. Now think about this scenario. Someone approaches you in a parking lot at night. They reach into their waistband. You believe they're drawing a gun. You fire. It turns out they were reaching for a phone. This is where the concept of reasonable mistake comes into play. Courts recognize that people must make split-second decisions. If a reasonable person could have believed the movement signaled an imminent deadly threat, the law may justify your action, even if you were factually wrong. But if witnesses say their hands were clearly visible and empty, that's different. Your perception must align with what an objectively reasonable person would have perceived. Another major issue is continuation of force. Self-defense only justifies force while the threat exists. If the attacker falls and is no longer capable of harming you, continuing to fire can transform a lawful defense into a criminal act. Jurors are instructed carefully on this point. Now let's discuss stand your ground for a moment. Many people think it's a magic shield. It's not. It simply removes the legal duty to retreat in certain places. It does not eliminate the requirements of imminence, proportionality, or reasonableness. Even in stand your ground states, judges can hold pre-trial hearings to determine whether immunity applies. If the judge denies immunity, the case goes to trial like any other criminal case. Here's another factor most people overlook: disparity of force. A smaller individual facing a much larger attacker, an elderly person facing multiple assailants, someone physically disabled confronted by a stronger aggressor. Courts consider those dynamics. A threat doesn't have to involve a weapon if the circumstances make serious bodily harm likely. But again, it comes back to evidence, lighting conditions, distance between the parties, prior relationship history. Were there threats earlier in the day? Was alcohol involved? Were there alternative exits? Every one of these details shapes the narrative. And let me say something that may surprise you. Even when someone is found not guilty on criminal charges, they can still face civil lawsuits. The burden of proof in civil court is lower. That means a jury could decide you weren't criminally guilty beyond a reasonable doubt, but still financially liable under a preponderance standard. So when people ask, what makes a shooting self-defense in court? The honest answer is this: it's not what you say, it's what you can prove. It's whether the evidence shows you were not the aggressor, that the threat was immediate, that deadly force was necessary to prevent death or serious bodily harm, that you didn't use more force than required, and that a reasonable person would have made the same decision in your position. Self-defense law is designed to protect those who truly had no safe alternative. It is not designed to protect pride, anger, or retaliation. Before anyone ever finds themselves in that position, the real preparation isn't just marksmanship. It's understanding how the law will dissect your decisions afterward. Because in the courtroom, every second is replayed. Every action is questioned. And the difference between lawful self-defense and a conviction often comes down to details most people never thought would matter. If you had to explain your actions to 12 strangers tomorrow, would your decisions hold up under that microscope?